The truth about Canada's High Court and gun owners. I'm Brian Lilley with TheRebel.media. See that statue behind me? That is supposed to be truth. On the other side of the Supreme Court building is a statue representing justice. I'm not sure either were served by this latest decision by the Supreme Court on mandatory minimums for illegal possession of handguns. Now, legal, law-abiding gun owners might be willing to celebrate a little bit today because the Supreme Court threw out mandatory minimums of 3 years in jail that could have applied to them for simple licensing infractions. But that isn't the reality, or at least it shouldn't be the reality. What actually happened is that the Supreme Court, the majority anyway, in a 6-3 decision, decided that they wanted to protect their favorite group, criminals, thugs. They wanted to protect them from harsh sentences handed out by the guys up the road in Parliament who sometimes pass stiff sentencing laws that make judges actually do their jobs. See, Parliament had enacted a 3-year mandatory minimum for unlawful possession of a restricted or prohibited firearm, especially loaded ones. Well, a couple of guys got caught up. These are not law-abiding gun owners, got caught up in them, and they challenged the law, and they won. They challenged the law not because it hurts them, not because it was cruel and unusual punishment for them, but because it could be cruel and unusual punishment for a law-abiding gun owner. And the Supreme Court of Canada, never really a friend to law-abiding gun owners, they decided to buy the argument. Let me read to you from the decision where they admit, well, the arguments put forward to strike down this law don't apply to the two guys challenging it, Noor and Charles. In this case, N and C do not argue that mandatory minimum terms of imprisonment in Section 95(2) are grossly disproportionate as applied to them. Rather, they argue that those mandatory minimum terms of imprisonment are grossly disproportionate as they apply to other offenders. Translation? There's going to be an awful lot of gangsters caught with illegal guns who are going to get lighter sentences because the Supreme Court of Canada bought the hypothetical argument that a law-abiding gun owner could go to jail. Now, I'm not saying that it wouldn't happen. I'm not saying it hasn't happened. In fact, I think that the problem lies not with the mandatory minimum sentences, but perhaps the way Crown prosecutors and police were applying them. Anyway, to continue reading from the Supreme Court decision, let me tell you what else they say. Section 95(1) casts its net over a wide range of potential conduct. Most cases within the range may well merit a sentence of 3 years or more, but conduct at the far end of the range may not. At that far end stands, for example, the licensed and responsible gun owner who stores his unloaded firearms safely with ammunition nearby but makes a mistake as to where it can be stored. Given the minimal blameworthiness of this offender and the absence of any harm or real risk of harm flowing from the conduct, a 3-year sentence would be disproportionate. Hey, justices in your robes behind your big bench with your big brains, here's a thought. Maybe strike down parts of the Firearms Act that are disproportionately, cruel and unusual punishment for law-abiding firearms owners. One of the tests that the Supreme Court is supposed to use when determining whether to strike down a law is whether any or part of the law can be saved. In this case, they decided, the majority anyway, that it could not be saved. They decided that they had to strike the whole thing down rather than, say, instruct Parliament to treat law-abiding firearms owners with a paperwork lapse differently than a gangbanger with 23 rounds in the magazine and 1 in the chamber. Because that's what this case is about. Noor was a man who was found outside a community center in the Jane and Finch area of Toronto with a fully loaded, oversized magazine shoved into a handgun. Charles, that's C in this case, he was found with an illegal handgun and 2 loaded magazines nearby. He didn't have paperwork for any. He didn't have a license. He hadn't registered anything because, let's face it, handguns still need to be registered as they have since the 1930s. But the Supreme Court didn't say, let's strike down part of the law. They said, let's strike down all of it because their favorite people, criminals, could be disproportionately impacted. Now, the majority said that this is hypothetical at best and didn't stand merit. Justice Moldova, writing for the minority, which included Justices Rothstein and Wagner as well, said this: In short, I conclude that it is not reasonably foreseeable that the licensing type offenses about which the majority is concerned to the point of striking down otherwise validly enacted legislation would ever be prosecuted by way of indictment. See, that's the thing. The prosecutor could go with an indictment, which would mean the mandatory 3-year minimum sentence, or they could go with a summary conviction, no more than 1 year in jail. With all the cases that the Supreme Court has punted back up to Parliament, they could have said, hey, fix this. But they didn't. They're not interested in that. They're interested in their weak on crime agenda. That's the real issue here. I don't believe that Justice McLaughlin or Justice Abella, that they're really interested in making sure that law-abiding gun owners who have a lapse in judgment or a lapse in paperwork aren't caught up in the net designed to deal with gangsters running around urban centers with loaded handguns that they have no right holding on to. That's the truth of the situation. That's the veritas.